Dear students in Allah's University, Faculty of Law, the English Department, welcome to the course named Private International Law. And actually, in this course, we will focus on the first and second subject matters of private international law, the nationality and the domicile. But before we get to the nationality and domicile and illustrating both of these terminologies, and before illustrating what is the definition of both nationality and domicile and the provisions related to both of them, I think it is a must to clarify what is the private international law itself. We have to know what is the difference between private international law and public international law. And we have to know also the characteristics and the subject matters of private international law and what is the reason that stands behind the naming of this branch as international law, despite the fact that it regulates relations between private persons, whether they are natural persons, I mean the individuals, or even legal persons or juristic persons, as we named them previously in the course of international law. Well, I shall start my lecture with a question. So as mentioned here, why is private international law necessary? So the question here, it tries to show the student why do we have to have this branch of law, which is the private international law. So we start with an example, and after that we will know what is the reason that we have private international law among the branches of the law as a mother law. So the example says if an Egyptian male married an Egyptian female. So let we use the pen here to annotate. I'd like to annotate the most important uh, things. So I will use the pen. Okay. So if an Egyptian male married an Egyptian female. So this is the first example. Says that there is a male and he wants to marry an Egyptian female. So this is the example number one. And notice here that the male and the female are both Egyptians. Okay? Or another example here. Let's imagine that an Egyptian citizen leased from another Egyptian citizen. Or Egyptian citizen, he bought something to another Egyptian citizen. Like it's a civil transaction that happened between these two Egyptian persons. And also in this example, both parties to this contract are Egyptians. Okay, this is the example number two. Or the example number three, let's say that these two parties concluded any other contract among themselves. Now, the question here, what is the law that this relation, I mean the marriage, or even the contracts, shall undergo? I mean, what is the law that is applicable to each and every single one of these transactions or laws? Well, actually, without hesitation, the law that must apply to these relations and transactions is the internal Egyptian law, whether it is the law of the married, the personal status, law or the civil law whatsoever. So, as mentioned here, in the first example, the relation will be governed by the code of the personal status. That's to say, the Islamic Sharia, for example, the male and the female, I mean the couples, are Muslim ones. Okay, while in the second exam on and in the third exam, the contract will undergo the Egyptian civil code simply because they are contracts. Okay, and actually they are nominated or unnominated contracts. In all ways, they will undergo, and the Egyptian civil code will apply to them. So the applicable law here in all of these examples is the Egyptian civil code. Why do we say this? Simply because the parties to these relations and the parties to these transactions are Egyptians. They do not enjoy any other nationality but the Egyptian one. Okay? So I don't think that we have any problem regarding the applicable law in this example, right? So let's continue. So the question was, why is private international law? We started with many examples. In these examples, I don't think that we have any problem. Okay, let's see the other examples. Now the examples here says, if we suppose that one of the couples in the first example is an Italian citizen, and let's use the bin also in order to annotate any important thing. Well, actually, here he says that there is two parties to a relation. The first one is an Italian person, whether he is the male and or the female, and the other one is an Egyptian one. So the relation is between an Egyptian male, for example, and the Italian female. Okay, or even let's imagine that the contract in the second example that we mentioned in the first slide, that the parties to the contract are Egyptians. We have no problem with this. However, the contract was reached in Italy. Or even let's say that both parties to the contract are Egyptian ones, no problem with that. But one of them bought a real estate from the other person or the other party, and the real estate is found on the Italian territories, and the contract of sale was made and concluded where? On the Italian territories. So let's say that in the first example, we have Egyptian who wants to marry an Italian girl. The second example, both parties are Egyptians, okay, but they concluded the contract in Italy. Well, in the final example, both parties are Egyptians, no problem. They are both Egyptians, and the real estate place is Italy. Okay, so it is different here from the first three examples, as in the first three examples, all of the parties to those contracts and transactions were Egyptians, and that's why the law applicable to these transactions is the Egyptian Civil Code or the Egyptian um, personal status code, according to the nature of these transactions and the contracts. However, let's back to our slides to complete. Here it says In these cases, I mean, in these examples, the different examples that we mentioned, there is a foreign element. What do we mean by the foreign element? We mean that there are two nationalities. So everyone looks foreign to the other party to the contract. So the Egyptian person is a foreign person with respect to the Italian one, and the Italian represents a foreign person to the Egyptian person. Okay? So in these cases, we do not have only nationals, we have foreign elements. So there is a foreign element in the relations which in turn forces us to search within another law rather than the Egyptian one. As in the first example, we have to find out the follows or the following. Look, since we have Italian girl and since we have a contract between Egyptians but it is made in Italy, we have to find out whether the Italian female, for example, is she capable to marry according to her law of nationality or not. Now, when I want to marry an Italian girl, then it may that my law allows this marriage. However, it may that the Italian law, I mean the law of her nationality, forbids this kind of marriage. Okay? Also, we have to know whether the contract that we concluded in Italy is valid according to the Italian code regarding the second example that we mentioned here. When we say that the uh, the the Italian made the contract with the Egyptian person or the real estate was made in Italy. So those examples, they oblige us to search within another law rather than the Egyptian one, simply because there is two nationalities. One of them is an Egyptian person, and the other person is an Italian one. So we have to know what is the law that is applicable to this relation. You may say, why don't we just follow one of them without any problems? We will say we will see the problems in the coming lectures, inshallah. If not now, I don't know if the time allows to show you the reason that it is hard to say that we must follow one of these laws and to choose one of them. We will see this later, inshallah. Okay, so here, as mentioned here, the examples are different from the first examples that were mentioned here, simply because we have a foreign element that is not found within the second the second examples. So let's continue. Why it is important to know what is the law that is applicable to the case or to the examples that I mentioned previously. This is important because we also want to find out which court is competent to hear the case. When there is a legal conflict arises between the parties to those contracts or to those relations in the previous examples. So it's not easy actually uh, to say that I must apply the Egyptian law and I have not to take into my consideration the other law, I mean the Italian one. It's not it's not like easy to follow this logic because there are problems that it may happen if I depend on one of these laws, as I will show you later, inshallah. Okay, so here I want, or I wanted actually, to make a comparison between the private international law and the public international law. I wanted to make a Zoom meeting with you, with all of you, in order to make kind of discussion on this matter. I mean, the private international law versus the public international law. However, the bad internet connections, it obliged me to make this Zoom meeting with myself, and just to record the lecture as it is, and then upload it and share it with you. So I will try to answer the question, or to make the debate here with myself. So private international law versus public international law. Well, private international law, guys, here is similar to public international law. Similar regarding what? Regarding the fact that both exceed the one territory in their application. So public international law is applicable outside the one territory, simply because it is applied in the international in an international scope, and it is applied in international society which exceeds the one territory of a one state. The same happens with respect to private international law, simply because it is applied outside the territory of one state, as we will show you, as I will show you later. Also, international treaties are considered as main sources of both laws, besides the international customs and judiciary. So we mention that both are international because, first of all, they exceed in their application the one territory of the state. Because when there is an Italian person, an Egyptian person, when, for example, private international law says that in this case, for example, Italian laws shall be applied, then I apply the Italian law to one of the parties who is Egyptian person. So it is like an Italian law was applied in Egypt, because this person represents his state. It doesn't represent the state in the meaning of the sovereignty, but simply because this person is an Egyptian one and the Italian law is applicable to him. So in this case, we can say, not literally, that the Italian law was applied outside the Italian territory. That's why we say that private international law is similar to public international law, simply because they both exceed the one territory of the state. Also, we say that both are international because the main sources of these two laws admit the international treaties, international customs, and international judiciary as main sources of both laws. Okay, that's why we say that both laws are similar to each other. What are the similarity points? The similarity points is that they exceed the one territory of the state. Number two, that they both consider and admit these sources, I mean the international custom treaties and judiciary, as main sources of both laws. Okay? However, here's the difference now. However, unlike public international law, private international law directs its speech to private individuals or private juristic persons. What matters here is that the private international law, it directs the speech of it to private whom? Private individuals. I mean, the natural persons, and a private juristic persons. So both are are private persons, whether individuals as natural persons, and the juristic persons or legal persons, like companies, for example. Companies, for example. So companies can be like part. to the clashes in the field of private international law, simply because they are private. So that's why the private international law is called private, simply because it directs its speech to private individuals and private juristic persons. And this is one of the differences between private international and public international law, simply because public international law directs its speech to the international actors and at the first place, the states. However, the private international law, it directs its speech to individuals and juristic persons like companies, but it has nothing to do with the states. Okay? Moreover, one of the differences also, private international law is promulgated by legislative authority. However, public international law is not made by legislative authority, simply because there is no authorities which are above the sovereignty of the states. And this is why some of jurists of international law try to deny the the law character or the legal character of public international law. They said because there are no authorities. So there is no authority, legal, legislative authority, which makes the public international law. However, the private international law is made by legislative authority, which made or which makes this branch of international law, the private international law. And there is طبعا there are not there is there are penalties accompanied with such laws provisions. Okay, so this is another difference between private international law and public international law. So let's forget all about these two differences. Let's move to the other slide here. Now, here is a question, and I think it is an important one. Also, I found it in one of the European books. It says, is it kind of paradox to name it as an international law, since the law regulate or regulates relations between private individuals at the first place? Why do we call it international? International, despite the fact that it regulates relations between persons in one of the territories inside one of the states. So why do we call it international? Well, private international law is described as an international one, despite the fact it doesn't regulate relations between two or more sovereign states, since it regulates relations that may include more than one nationalities or one nationality. I mean, persons, they belong to different states. That's why we call it international. International not because it it is applied internationally between states or sovereign states. It is international because it is applied to the relation between persons who are foreign to each other. They look different to each other regarding their nationalities, and they are persons who belong to different states. That's why we call it international. So it is international not because the relations between the states themselves, but between the persons who belong to these states, to these different states. Also, it is labeled as private because it governs the relations between private individuals, private juristic persons, who are companies, for instance. Okay, so that's why we call it international. And anyway, when we talk about international law, then it means the public international law. So international law itself, I mean, uh, when we mention international law without labeling it with private or public, then it reflects the public international law. However, when we talk about the private international law, we have to label it with private international law. We have to put private here, okay? When we are talking about private international law or about this branch. Okay, now let's move to the definition of the private international law. And before I start, I would like to tell you something, or I want to remind you something. Now, do you remember the definition of the international organization? Well, if I am the one who taught you that course, I would like to remind you that the definition of the international organization varies according to the elements that are included within the definition. I mean, the elements of the organization itself. So some jurists give the definition for the international organization based on one or two elements. That's why the definition of the international organization is a very simple definition, and uh, it contains only two or one element maximum. However, other jurists may give the international organization a definition which is about 4 or 5 lines, simply it because it contains or consists of more than 5 elements or 6 elements. That's why the definition becomes wider than the definition of the first group of jurists. Now, the same happens or the same goes for the definition of private international law. The definition of international law, I mean private international law, differs according to the number of the subject matters that are covered by the private international law. So I, for example, as a private international law instructor, hypothetically, because it's not my field of interest, I would say that private international law is a law which regulates and governs the relations which contains the foreign element, and it covers 6 important subject matters. Now, 6, and I have to mention them within the definition of mine. However, it's made that other people who teaches private international law, they do not have the same perspective about private international law. They do believe that there are only 3 subject matters that are covered and that are concerned with private international law theory. That's why their definition will only concentrate on those 3 subject matters. So the number of the subject matters, it is the thing that decides what is the private international law magnitude, whether it is a wide definition or a simple and small definition. Okay? I will not start now with the definition of private international law. I think I will give you the definition of private international law, inshallah, in the coming lecture. Now I leave you with the mercy of Allah. Thank you for being patient and see you, inshallah, in the coming lecture, and goodbye.